This is an AZ Court Help Legal Talk on spousal support, calculating alimony. Thank you.
Welcome again. I'm Steve Wolfson. I'm an attorney with Dickinson Wright. I'm here in Phoenix. I've had the distinct honor and privilege of participating on several Arizona Supreme Court committees designed to further and refine and reform Arizona family law in a number of different aspects. Participated with the committee to establish the spousal maintenance guidelines that we're going to talk about today. The guidelines, need to be reviewed. So take an opportunity, and we're not going to go through them page by page today, but take an opportunity to read through them at least once if you have that issue in your case, either as an attorney assisting a client, or if you're representing yourself. Try to read through them. They're designed to be as user-friendly as possible. By that, I mean, we made every attempt to describe them in as plain of terminology as was possible. There are obviously terms that may not be understandable or readily make sense to someone along the way. But try to read them to at least get a flavor for what the guidelines are doing and why they're doing it. Ultimately, this is all connected to the determination of spousal maintenance, the amount of spousal maintenance, and what we call the duration, or the amount of time that the award of spousal maintenance will be provided or granted from the court. And so this is all how to get from point A to point B, from the request for spousal maintenance to a final order of the court or an agreement, because one of the purposes of the guidelines, among other purposes, was to encourage settlement discussions by giving greater uniformity to the determination of spousal maintenance. Over the years, depending on the judge, depending on the court, whether it's a court in Coconino County or the court in Maricopa County, there might have been a wide variation in the amount granted. And so one of the purposes of having more standardized guidelines is to have more standard results and expected results throughout the state. If there's a common knowledge about what a calculation of spousal maintenance might be, whether it's husband or wife, mother or father requesting it, then that may lead to better discussions about resolving that issue without involving the court. So that's one of the purposes of having the guidelines in the first place. It's not meant to stifle discussions where the circumstances may be outside the guidelines, such as in longer-term marriages or individuals who may have conditions or difficulty earning any income. But in most cases, or in certain cases, they are applicable and should be looked at. With regards to the applicability, it's important to know that if the case was started before September 24 of 2022, so September 24th of a year ago, the guidelines are not applicable unless the parties agree to have them apply to the case. That doesn't stop either party from looking at them or running a sample calculation to get some feeling for where the guidelines would come out, but they are not applicable by the court unless the parties agree. So if for some reason the case has been going on for a year, but it was started in August of 2022, the guidelines would not apply unless the parties agree to have them apply. If the case, as many ongoing cases, started after September 24th of 2022, the court must apply these guidelines. And in most courtrooms, with most judges, they will require you to submit a calculation to the court, similar to how you would be required to submit a child support worksheet and calculation to justify the amount of spousal maintenance requested. So on your screen right now, you're seeing obviously it's self-explanatory, the spousal maintenance calculator. This calculator, this page that you're seeing right now, appears on the Arizona Supreme Court website. You can also see that it says this calculator is for statewide use. This is only a screenshot if you were on the Supreme Court's website. And all you need to do is, as my daughters like to remind me, Google Arizona Supreme Court guidelines. The Arizona Supreme Court website will be one of the first links that you will see, and you will be able to go directly to this fillable calculator. This is not, to the best of my knowledge, a calculator that you can download and use again. I'll get to that in a second. This calculator can be populated with information, and then I believe you have an option of printing it out. So if you need, and your communications with the court involve submitting a spousal maintenance worksheet or calculator, this should be one of your options. And we'll get to the specific fields in just a second. Another purpose of the calculator is to reflect the new focus of spousal maintenance determinations under Arizona law. So without getting too far into the weeds, in 2022, the new legislation was passed to change, not in a significant way, but it did change the spousal maintenance statute 25-319, as I mentioned before, to focus the determination not as much on what the court believes is appropriate or just, but on what amount and duration is appropriate to allow that spouse to become self-sufficient. You will hear references to self-sufficiency, to becoming self-sufficient. What is it to be self-sufficient? In all sorts of variations, but self-sufficient and self-sufficiency are the focuses of the spousal maintenance guidelines for 2023. So in one way to look at it is economically, what is the amount that a spouse needs to provide for their own living expenses in an amount, or excuse me, in a duration that, again, is appropriate based on the guidelines. And there are specific amounts of time that are now given based on the years of marriage. And I'll point that out. But that is a change from the way that the statute existed before. It was much more open-ended, much more subjective for the court's determination. The spousal maintenance determination is, by contrast, now much less subjective and much more uniform to, as I said before, have similar results in different counties throughout the state of Arizona, and not have such dissimilar results based on which judge the case might be presented to. Having said that, there are exceptions, and those exceptions are called deviations. So if you believe you have a unique situation that merits looking outside of and beyond the guidelines and the straightforward calculation by the calculator, you should look at the deviation section of the spousal maintenance guidelines. That's section 6. And when you look at the guidelines, you'll see that begins on page 19 of the guidelines, and it describes what factors and what criteria you need to meet in order to convince the court that the court should deviate either in the amount or the amount of time, the duration for spousal maintenance. There's more discretion for the court to deviate as to the amount, and less, if any, discretion to deviate on the amount of time or the duration. But nonetheless, as far as the tools that you have in your toolbox to say, yes, Your Honor, here's a sample calculation, but I'm asking you to deviate, to use a different number, and here are the reasons why. So you should keep that in mind if you believe your particular situation merits the court having a deviation. So getting back to the calculator, it begins by putting in, kind of name, rank, and serial number information concerning your case. The court needs all of this, dates of birth, the date of marriage, which, as I just said, is very important for the duration, because for different periods of time, for different lengths of marriage, you will have the guidelines provide for a different duration of spousal maintenance. The longer the marriage, the longer the period of time that the court can look at for the duration amount. And there are still ranges that the court can look at. It's not just one number. A marriage of 8 years gives a spousal maintenance of 48 months. It doesn't work that way. It gives the guidelines, and the calculator will give a range for the duration of spousal maintenance, as will the calculator give a range for the amount, depending on all the rest of the information. So towards the top of your screen, you should see family size. That is also described in the guidelines. It's very important because the family size affects the calculation of spousal maintenance. The family size would include all persons that you or the other party has a legal obligation to support. So if there's an adopted family member, that person should be included. You do not include individuals. Maybe there's someone else staying in your household, friend, family member, that you do not have a legal obligation to support. That individual should not be included in the family size. What you can also see here are, quick links. And when you click on those blue areas, they will take you to an explanation that may answer your question about what to include. So, for example, the next line, which has generated a certain amount of, I wouldn't say controversy, but questions about why are we including monthly mortgage principal. You clicked on the blue dot, and I don't think it would work for us right now because, again, we're working with a screenshot. It would describe to you why are we including mortgage principal. And in a nutshell, I can tell you that there's economic data that's been used as the foundation for the numbers that get spit out down below for the spousal maintenance guidelines. Again, you'll ultimately see a range, kind of low, medium, and high. Those numbers are all based on nationwide data about living expenses for sizes of families, and at certain income levels. I mean, there's a lot more that goes into it, and I believe there's also a connection link on the Supreme Court website for the economic data, if you're so inclined, or if you just have trouble sleeping, to understand better where the data comes from. But it's based on nationwide data, and that data did not include house expense, the principal amount, because in that data, that nationwide data, that expense was looked at as an asset as opposed to a living expense. So it's been included. Whether it stays there in the future remains to be seen, but it is the principal, not the entirety of the mortgage payment. So in many cases, you have PITI, principal insurance taxes. You only want to include the principal amount from the mortgage, and that amount then goes in the worksheet. This is for all the residences that the family uses. So if there's two separate households, you would have the principal from both. That goes in that field. You do not include investment property. So if there's a property that's rented out that the family does not live in, you would not include the principal on any mortgage for an investment property. Now we're into the income section, but this section on income then is the next section. It's very important. It's similar in many respects to the child support information that needs to be provided to the court. In the child support calculator, as you may know, the Arizona child support guidelines are based on two different income amounts, gross income amounts, and this is a very similar process based on almost identical principles with a couple caveats that I'll mention. So spousal maintenance income is kind of a term of art. It's meant to be broad because it includes a variety of income sources. It can be very different types of income, whether it's interest income, dividend income, salary, bonus income. There are all sorts of different types of income that can be included and should be included in this first line for actual spousal maintenance income. The next line is attributed spousal maintenance income. So that's a reference to a situation where a spouse may be unemployed or underemployed. And again, this is very similar to the same types of examinations, analysis, determinations of income that exist in the child support guidelines. Does income need to be applied or attributed to a spouse based on their full earning ability versus what might otherwise be occurring? So if there's a spouse and he or she works part-time but could work full-time based on, again, different factors that are mentioned in the spousal maintenance guidelines, then you can argue to the court that that individual should have full-time earnings attributed to them. They don't actually exist, but the court can choose to include a full-time amount in the spousal maintenance determination. So the court can, not only can the court look at a full-time amount of income in terms of numbers of hours, but the court can look at the amount. So there might be a situation where the individual, the parent, the spouse, is only capable of earning minimum wage full-time, but there might be a situation where, based on the experience, training, work history of the spouse, they're able to earn more than minimum wage full-time, And you would also have the opportunity then to include that amount in the spousal maintenance calculation. Then as you see, it totals the both of them and gives a monthly amount, will populate automatically a monthly amount for both individuals. As I mentioned, that there are a few caveats. One is property, how the property or other assets affect income for purposes of the spousal maintenance calculation. What I'm describing is if your family is fortunate enough to have property that can generate income. So, for example, if there's a investment account, non-retirement, because retirement has other tax implications. So we're talking about non-retirement assets that are beyond $100,000 in value. I say beyond $100,000 because the first 100,000 is excluded. So the court will not look at if there's an account of 100,000 and that account is going to be divided, so 50,000 for each party. Again, non-retirement, the court will not, that alone would not affect what we're talking about right now in terms of calculating income. If it's more than 100,000 per party, so let's say the account, it's a money market or other type of investment account, and it has $300,000 in it, the first 100,000 is taken off, and then we assume that the remainder, for purposes of this discussion, the remainder of 200,000 is going to be divided between each spouse. So the spouse requesting spousal maintenance will have income, investment income on that remaining 100,000. 200,000 divided in half, 100,000 per spouse. That 100,000 would be attributed income at 4%. Why 4%? Because that's the amount that's in the spousal maintenance guidelines, and that amount would be additional spousal maintenance income. But then we get, after working on the income, we get to the actual calculation. This is auto-populated, again, based on that underlying data, which actually comes from the U.S. Department of Agriculture, and it's been slightly, tweaked by the committee who established the guidelines, comes out with the monthly calculation. And as I described before, you will see a low, a midpoint, and a high. That is the range that you would submit to the court, and the court can look at, is there a reason why the low amount should be used versus the midpoint or versus the high? And the court has the discretion to look at that entire range to decide the amount to be awarded. Below that, you see a box to check on a deviation. Again, that's under Section 6 of the guidelines to describe, when that would be appropriate. And some of the factors for a deviation would be that a request is made for specific reasons to be the amount to be outside of those ranges. That would be one reason. And without requesting a deviation, the court will be required to use that range to come up with an amount within that range for the spousal maintenance amount. One other kind of side note is that if this entire process encourages both spouses, either with counsel or without counsel, to come to an agreement, and that agreement amount is not exactly what's in that range, that's not a deviation. That's an agreement that the court should respect and most likely would respect, and approve. So just because you're discussing a different amount that may be $5, $100 different, either to the low side or to the high side, that's not a deviation. It's when the court has to get involved to look at the request that is either above the high end or below the low end. That's when the court would have to decide if a deviation is appropriate. And in a nutshell, the court has to look at the range and decide that it's inappropriate or unjust for a particular reason. And it has to identify what it would be if it doesn't deviate. And then it has to decide what amount it's going to order. So there's a 3-part test analysis that has to take place. But the point is that if you think you have a unique situation, then you shouldn't hesitate, in my opinion, to use the deviation to ask the court to look at different facts, different reasons, to do something outside of that range, the calculation range that you're looking at, low, medium, high, either on the low side or above the high side. When you look at business income, you may have a business that generates 100,000 gross in a calendar year, but certain certain amounts of income need to be paid to either taxes or for the mortgage on a business building, or for salary. So the court generally will exclude expenses. Well, let me turn it around. The court will generally only look at the amount of net business income after the expenses that are needed to maintain the business are reflected. So to put this in a different context, if you have a rental property and the apartment, condominium, or house is rented out, you have expenses usually with a mortgage on the property. You may have upkeep and repair expenses. You may have an HOA expense. All of those expenses could be removed from the amount of revenue before you would get to the income amount. So if after the expenses, using my $100,000 as an example, you were left with net income of $36,000 after all the expenses were paid, then you might only be looking at business income of $3,000 a month. So in general, and again, every business is different. Some businesses are owned with other individuals. Some businesses, don't have the same types of expenses. But in general, you should demonstrate to the court, and the affidavit of financial information would go in tandem or hand in hand with that presentation to the court, to show the amount of business income after the expenses needed to operate the business are subtracted. So that's the best answer I can give there. The guidelines refer to it. This is section F on page 8 of the guidelines. Actual income from self-employment, rent, royalties, business or jointly owned partnership, closely held corporation, calculated by taking the total income received before any deductions or withholdings minus ordinary and necessary. Those are the terms of art. Ordinary and necessary expenses required to produce the income. So again, what ordinary and necessary expenses does the business owner have in order to operate the businesses? And then those expenses actually include not the total taxes, but only 1/2 of the self-employment tax that's actually paid, and your accountant can assist you with that. But that's a very specific tax figure. Otherwise, you need to come up with that calculation and not merely base it on what you decide to remove from the business, either by way of salary or draw. It's based on the amount after considering those ordinary and necessary expenses needed to operate the business. What you're looking at now is also a spousal maintenance calculator. The other was a screenshot based on what's available as a fillable calculator on the Arizona Supreme Court website. This is an Excel spreadsheet. So it does the same thing. It has a little bit more information included on it. So it's not as pretty, it's not as streamlined, but being in Excel format, you can save the calculator. You can include, obviously all the, basic information about the parties, family size, etc. And then you could always go back and save another version. So if you were getting information from your spouse or from the other party, if you're representing a client, you can do a draft calculation based on preliminary information that you may have available to you, save that, and then update it, save a new version once you get additional information. So you see on line 11, you've got the family size. The family size, again, has a significant impact on the amount range that will eventually be spit out by the calculator. Below that, you see annual actual spousal maintenance income, exactly the same as the Arizona Supreme Court prettier version that we talked about. And then you see right below that, additional annual attributed spousal maintenance income. So again, that's a reference to income that doesn't necessarily exist or exist from sources outside of employment. So again, that might be rental income. It might be income attributed to property based on the 4% that I talked about before. And that's where that number would go. And then you have the annual amount that will automatically populate, the combined monthly that will automatically populate. And then on line 25, you see the family monthly mortgage principal, which again does not include taxes, insurance, or other amounts that may be in an escrow account. It should only be the principal. You should be able to see this very quickly from a mortgage statement, which always will list out mortgage and interest separately, or excuse me, principal and interest separately. If you don't have it, if you're on the mortgage, you should be able to contact your mortgage company, get a copy from them directly. If for some reason your spouse is not providing you access to that information, otherwise there's discovery and disclosure available within the case to get a copy of the mortgage statement, which breaks out the principal versus the interest. So now we're looking at a more detailed version of the range that we were talking about before. I like this version because it's an Excel spreadsheet. You can save it easily to your system, either on your home computer or if you're representing a client, to that particular file. You can update it and you can see how the information or how the ranges change. This does give more information that is somewhat confusing if you're not well versed in the guidelines themselves. I wouldn't get too caught up with the expenditure lines, the indivisible expenditure lines, indivisible divided by 2. I would then focus on the last three lines, which is a combined amount, a payee share, and then the amount range is obviously and literally the bottom line of what you would be presenting to the court as that range for low, midpoint, and high. When you look at it, sometimes there's, for lack of a better term, sticker shock, either for the payee or the payor, the person receiving or the person to pay, because of the underlying data. The amounts sometimes are not what people expect them to be. Either they're lower than what they expect, or they're higher on what they expect to pay. It's somewhat counterintuitive that the data seems to trend that the higher income amounts, the amounts are higher to be paid than what people expect. And at the lower income amounts, they seem to be more reflective of what most individuals would expect their expenses to be. Again, as they say, your results will vary. Every situation is different. But the worksheet itself is designed to start with the income either currently being received, the actual amounts, or the amounts that the individual, the spouse, let's say, for example, that's requesting spousal maintenance, that they're either capable of earning and by the court's determination should be applied or attributed to them. And then those amounts are sort of deducted, or the ultimate spousal maintenance amount is adjusted because of the income that spouse is expected to obtain or receive. There's something else I should mention, because if you're involved in a case, whether personally or representing a litigant, you know that there may be orders entered by the court, temporary orders at the beginning of the case, that are different from the final orders. The spousal maintenance guidelines are generally not applicable to temporary orders and can be looked at by the court, and many judges will look at them, but the attribution of income is discouraged, if not outright prohibited, to do as part of temporary orders. So, in a more direct way of saying it, if there's a spouse who has not been in the workforce for a considerable period of time, and is only exploring at that point in the beginning of the case, exploring his or her options for either gaining work experience, apprenticeship, going back to school to brush up on computer skills or other skill sets, and needs time to get up to speed to re-enter the labor force, the court should not be generally attributing income under those circumstances. If the spouse, however, has more recently worked, the court can look at doing it again under appropriate circumstances. So that's a difference, a significant difference that is ingrained and described in the spousal maintenance guidelines. That is whether or not to attribute an income as part of temporary orders versus what will be done with attributing income and earnings as part of the final orders of the court. So I hope this was beneficial in the time that we had today. If you have comments or questions about ways to change or adjust, or problems that you see with the guidelines, I would try to pass on that information to the Arizona Supreme Court through the Arizona Supreme Court page on the spousal maintenance guidelines, where they're seeking that input. Take care. Thank you.